'cause I took a break. You're making a huge mistake, thinking you can take the throne. Look at you trembling, step into the lion's den. Bet you wish you stayed at home, begging for mercy underneath your breath when I ain't even sweating. Yeah, my legend's written in the stone. Yeah, you're crying age, you're in defeat is now your only friend. Even your mama's gotta know. First round, you thought you would've knocked me down. Fifth round, bleeding out the side your mouth. Final round, only the sound of my name in the crowd. You didn't bust. Oh, 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 oh. You didn't bust. Oh, 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 oh. First round, fifth round, final round. Oh, 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 yeah. First round, fifth round, final round.
One day more, another day, another destiny. This never-ending road to Calvary. These men who seem to know my crime will surely come a second time. One day more.
Not live until today. How can I live when we are parted?
One day more.
Tomorrow you'll be worlds away, and yet with you my world has started.
One more day along my road.
Will we ever meet again?
One more day with him not caring.
I was born to be with you.
The life I
welcome
Special
welcome everyone to After Dark. With me today is 𝐓𝐢𝐬𝐿. 𝐓𝐢𝐬𝐿, how are you?
Doing good. Apparently, we have special guests.
Yeah.
I was excited.
Well, did it actually? Oh, yeah. Well, sometimes we have special guests. Today we just have the regular guest host. I guess you're.
I'm not special.
You see, well, you have two titles.
Lie
You see,
to
I'm
me.
just a host. You're special. It's a very different kind of special. It's this conversation headed south quickly. Yeah. I'm so glad I got up out of bed to.
And who turned south and ran with it?
Yeah. Okay. Fair. That's fair. Welcome everyone. Thank you so much for joining us. This is a call-in show, so if you want to call in, you can give us a call. It's 484 2 in time. So that's 1-484-246-8463. You can also come in through the any web browser. You can come in. We haven't decided yet on whether or not we're going to do cameras. Right now, probably not. We will have audio, and obviously, this can be a very contentious topic. Really, the topic of tonight's show is not abortion. Believe it or not, it's the SCOTUS decision and the implications thereof. Obviously, abortion is going to come up. Obviously, people's views on it are going to come up, and that's marvelous. I think I want everyone to express those views. We are not going to be debating that particular topic. What we're going to be doing is. And there are plenty of forums to debate that, as I'm well aware. We're going to be discussing what this decision, if it is rendered as written, which may or may not. It's not going to. I will tell you this. There are people who've said that, they may change their votes, yada, yada, yada. I'm not even sure how practical that would be. That's not going to happen for any number of reasons. I'm hoping that the decision gets watered down. Because it's actually an extraordinary decision. We've been discussing it some on the Discord. This is the way I'd like to frame it, just so that people understand. When Roe v. Wade was first decided, one of the interesting things about it, nobody had any idea how many other decisions would be based on it that had nothing to do with abortion. Now, the question is, how many of these are now up for grabs? And I'd like to discuss that, and we will discuss that. But that notwithstanding, that made Roe v. Wade ultimately, in 50 years, a pinnacle decision about privacy and expanded rights for everybody. Gay marriage actually hinged on arguments made in Roe v. Wade, and any number of, I forget one that was actually a shock to me. I've forgotten. It was a very esoteric one that had been decided, and Roe v. Wade was a cornerstone in that decision. So we have 50 years of all of these other decisions that rest on Roe v. Wade. Let me tell you, my read, and I've read it several times now, of Alito's draft decision overturning it doesn't read like it's overturning that per se, as much as it's attacking any number of other principles on which Roe obviously stands. And what's interesting about that is, if you thought Roe v. Wade had repercussions outside of abortion that affected the entire United States, you ain't seen nothing yet. It seems to me that was quite deliberate to not only overturn that, but to have a tremendous assault on any number of progressive principles that have been enshrined, whether out of Roe v. Wade or not. The precedence that this sets, despite saying it doesn't, which is laughable in my view, and we'll get into that, I'm sure, is stunning. And this is at least as profound as Roe v. Wade was on any number of other topics. So, I don't know. Is Andrew any thoughts on that before we discuss it? Yeah, please.
Yeah, it also is interesting in the fact that it overturns two previous decisions, not just one. It overturns Roe versus Wade and Planned Parenthood versus Casey. So it overturns both of those decisions, not just one.
It does. And so you had mentioned earlier, and I think that this is on an issue that is wrought with so much. It's such a personal issue to so many people, as well it should be. This is not a criticism, but it makes it hard sometimes to find the nuance and to discuss elements of it that may seem unfair, but are nonetheless practically have certain practical implications. One of them being, you had suggested this, and I very strongly tended to agree with you, that the Roe decision, while in fact, I think you agree with the conclusion, and I think obviously most of our audience agrees with the ultimate conclusion that a woman has a right to choice. The grounds that Roe uses, and I do want to discuss that, actually the argument that Roe uses doesn't make a lot of sense to me, and I think most legal scholars have said that actually that at least the reasoning that they used was poor. Doesn't mean the conclusion was wrong, but the reasoning was poor. Is that roughly sort of your position on this?
Yeah. Roe was very poorly reasoned out and poorly decided.
I usually make the distinction that it was decided maybe correctly, but for the wrong reasons. Just because that's a technical, I think is roughly what. So you don't agree with why it was decided the way it was, but you agree with the conclusion that women do have a protected right to choose. Is that?
Yes.
Yes.
Right. And this is one of the reasons why it's like I've just about all of the constitutional scholars I've ever listened to talk about Roe versus Wade, talk about the incredibly poor rationale behind it, backing it up. But almost none of them thought that it should be overturned because it's been there for 50 years. There was a lot of other things based off of it. So they didn't think that, even though that they thought that the reasoning upholding the decision was horrible, they didn't think that it would be wise to overturn it at this point because so many other things are based off of it as well. And that's where I run into the problem of, it's like, well, I don't want laws based off of, poor reasoning. It's like you should have good, solid foundations for the laws that you have. Otherwise, they're subject, like we're facing now, they may be subject to challenge in the future as well. I think it's a much better idea to get a good solid basis for your decisions, and of course the right to bodily autonomy is my basis for supporting abortion rights. And the fight comes down to, which it usually does, and which a lot of Supreme Court cases end up being about conflicting rights and which right ends up taking precedent, because you have the right to life from the unborn human, and the right to bodily autonomy to choose whether somebody else, another individual, has the right to use your body against your will, even to sustain their life. So it comes down to a clash between those two rights, and I think that's what should be focused on in a Supreme Court decision, enshrining that no, you have the bodily autonomy, you have the right to choose if another individual can use your body without your consent. And I believe the answer to that is no. You don't. And the other person's right to life doesn't trump your right to not have your body used against your will, even to sustain their life. So it's but at the same time, it's going to look at all of the problems it's going to cause right now. It's like, yeah, overturning it should probably be done, and maybe 50, 100 years from now, we'll look back and say, yeah, that was probably an important thing to do, and we're glad we did it, but it's going to cause a hell of an upheaval right now. But by shutting that decision down now doesn't forestall it from happening again in the future, because it is not well substantiated. Pretty much everybody, all constitutional scholars, law people that look at this have all kind of agreed that this was on really shaky ground. They couldn't point to something in the Constitution to actually, underpin what their decision. They threw a whole bunch of stuff at the wall and said, well, it's in there somewhere, we're sure.
Yeah, I remember that part too. It really does say that. Yeah. So all right. So and the amount that needs to be unpacked here is actually staggering. I do want to get into this. There's a fallacy, and when I teach logic, I talk about this. The fallacy, which is you can have completely wrong premises and a very bad argument and still have the correct conclusion. The argument I usually give is, Boston is in Russia. Russia is in the United States. Therefore, Boston is in the United States. Well, the conclusion is correct. Boston is in the United States, but both of those premises were dead wrong. So, just because somebody makes a bad argument doesn't mean they're wrong. It just means they haven't substantiated their claim. I think, there's a whole bunch of laws that I don't like, but I don't like because of reasons like that. I agree with the principle behind the law, but I don't like how it was done. And one of the things that people don't often realize is when you're arguing before the Supreme Court, it's actually a very personal thing. What people will do when they're going to argue before the Supreme Court is they'll sit down and figure out what is important to each justice. They're not arguing to the United States. They're not arguing to the American public. They're not arguing to legislators. They're arguing to 9 very specific people. And they're very aware of that. And, so what they'll do is any legal team or any lawyer that's doing this, if they know that they're going to be giving arguments before the Supreme Court, they sit down and they say, which arguments are likely to resonate with which judges? Which judges do I have the hardest time with? Which votes are in play? Roberts, obviously has often been one. So there's a whole bunch of where am I going to find votes, and how do I approach it for those individual people? So sometimes, and I don't know enough about the history of Roe v. Wade to know if that's what happened here, but I suspect that. I suspect that when it was being argued, they didn't look at the quality of the arguments overall or even over time. They looked at how are these arguments going to affect the specific justices that are in play. We probably have a few that are going to say no matter what, a few who are going to say yes, no matter what. How do we get the swing votes? And then they will. The number of times, like Justice Kennedy was one that I mean, you would see decisions and you would see people arguing just to him because they knew he was the swing vote. So they would be arguing specifically arguments that would work on Kennedy and nobody else. And so they're actually arguing this case to one person, and they study every decision he's ever made. They study everything he's ever said, and they're arguing to him. And they know it. The court knows it. They don't see, I don't know if they take offense to it or not. They know the practicality of it. Hold one second. Sorry. But that's how it's done. So I don't know if that's part of how and why privacy became the issue. But Porpoise is already causing Porpoise hasn't even mentioned the topic and is like, oh, it's Hamilton. Oh my God. Valjean and Hamilton. Porpoise, really? Some people just don't want to take anything seriously.
Oh, the
just saying.
other,
yeah, please.
Other interesting thing is I have not forgotten that the 10th Amendment exists, which roughly states that all powers not delegated to the United States nor prohibited to the states are reserved to the states or the people respectively, except that when we're talking about fundamental human rights, which are mentioned in the Constitution, therefore it prohibits the states from doing those things. This is one of the arguments why especially in the Second Amendment, we ignore it. First Amendment, we don't. The Fourth Amendment, we don't. Second Amendment, of course, we do because states pass all their own gun laws all the time. So, you can't tell me that the way that things exist now, I mean, if we actually followed all of the amendments and followed the 10th Amendment as well, the United States government couldn't do most of the stuff that it's doing now, and it couldn't make a single law against gun ownership. Nor could it abridge your freedom of speech, nor could it not make you secure in your persons or beliefs or persons or papers. There's a lot of things, and then of course a few things that you can do that we don't have to ever worry about anymore, like housing soldiers against our will. But when it comes to fundamental human rights, territory doesn't change whether somebody has a right or not. Doesn't matter if you cross state lines. Doesn't magically change your rights. You have all of the same rights in all 50 of the states. So, the 10th Amendment wouldn't even apply in this particular instance, which I find interesting because, if they do overturn Roe versus Wade, it now again becomes a state deciding whether or not, deciding on fundamental human rights, whether you have the right to bodily autonomy or whether the baby has the right to life, and which one of those is more important.
I will, just so the Porpoise knows when I laugh at the wrong times, we've added about a 30-second delay to the show for obvious reasons. This is H.R. 3755. This is the resolution to enshrine Roe v. Wade into law. It's a cray-cray bill. But having said that, I was reading it, and what I thought was I was reading it. I said there's just one line that I really hope is not in here because I don't want to have to talk to Xandring about this. I really don't want to. I was like, it can't be in here, and I was just like, I know it's going to be in here because just like reasons, I just know for a fact it's going to be in here. So I was reading it, Article 25. Oh, I died. I died inside when I read this. Congress has the authority to enact. To enact this act. This thing is horribly written, but to be fair, they had like a less than a week to write it. But Congress has the authority to enact this act to protect abortion services pursuant to its powers under the Commerce Clause, Section 8, Article 1 of the Constitution of the United States. Yeah, I didn't want to have to tell you that. Wow.
Gotta love the Commerce Clause, which that's a colloquial name for it. But yeah. Let's just take something that was meant so that New York couldn't completely choke off all of New England and cause severe depressions, etc., in retribution or punitively do things to New England. Let's just take that premise that you didn't want another state, between the states. And let's totally twist and corrupt that to allow us to do just about anything we damn well please.
Yeah, you can really abuse that clause. And well, again, I'm for much of the legislation that was actually used that clause. Come on, some of it's just like, yeah, that's not interstate commerce. All right, so give me 1 sec here. Once again, I apologize.
That one really bugs me. I don't like it's way abused.
Yep. So all right. So what I want to do, I want to talk about the draft decision, and I'm going to say a couple of claims, and if anybody wants to argue them, give us a call. 848-2-IN-TIME, or you can live.intimeshow.com. Come on in and join us. It'll work on a phone, any browser, whatever you want to do. Come on in and say hi, and we'll talk about it. But I want to suggest a few things. So first of all, this is the draft written by Alito. We did break that about an hour after Politico came up with it, and it's a pretty staggering statement. My overall impression of it, and I've been discussing it with a number of people, and everybody's been talking about the Roe element of it, which obviously makes a tremendous amount of sense, and that is absolutely the most proximate victim of this. I'm not sure it's the biggest potential victim. Well, it's certainly not the biggest potential victim. It's one of them, but it ain't the biggest, I don't think. I'll get into how and why. It gets back into what we were talking about precedents earlier and what I think this sets a precedent for. But my read on this decision, I think because there were these, at least, we look back on it, a lot changes over 50 years. Language changes over 50 years. I know we're going to be getting back to that one. And what seemed like a good justification 50 years ago may not now, but I do concur that there were errors in how the original one was decided. Not the conclusion, but certainly the reasoning behind it, I think, didn't fit. And that's why also, too, judges, you'll have a majority opinion, but you'll also have other judges giving their own opinion. They'll say, well, actually, I agree with the opinion of the majority, but for completely different reasons. In fact, the majority is dead wrong on their reasoning. That happens reasonably frequently, too. This one looks like Alito was expecting everybody but perhaps the Chief Justice to agree with his reasoning. The Chief Justice was purportedly, we think, actually hasn't voted yet. We believe Roberts, I think there's a 50-50 that Roberts will vote for or against. If he votes for, it ain't going to be for this reasoning. He's going to write his own opinion, I suspect. So sorry for the reversal. But here's the thing. If Alito wanted to, and I'd like to point out something I wanted to say earlier, all these justices that have voted for this thing actually went before the Congress of the United States and said it's settled law, nobody's overturning it. And you can't just overturn precedents, especially one that's that enshrined. And something along those lines was said by every judge that appears like they're going to be signing off on this particular decision. So I want to make a couple things clear. So first of all, just in terms of language and what we're talking about, they have voted. the vote is done. It's 3-5, and it's either going to be 3-6 or 4-5, depending on how Chief Justice Roberts votes. He hasn't voted yet. Can they change their votes? It seems like it's possible. I don't know what the precedent for that is. I don't know how often it's happened. They're very secretive about this kind of thing. Was this leak a good idea? No, I'm in general against this kind of thing. Are there possible exceptions? Yeah. Does this fall under that?
A second?
Please. Yeah.
One of the things that I was thoroughly impressed with after getting off of, I mean, because we came out, so close after, the initial reports of this came out. And when we talked about it, we actually put a pretty big emphasis on the fact of the leak itself and how unprecedented that was and how much, how troubling that was and the kinds of damage that could cause. And right now, about the only media that I've ever seen even talk about the leak as a damaging thing, a bad thing, has been from the right, which they seem to scream that left and right and not really wanting to get into the abortion issue at all, instead of standing up and gloating so much. I mean, there are some that are definitely doing that, but, they're really hounding on how bad this leak was. And then from the more liberal-leaning media, I've heard them go as so far as to call the leaker a hero.
Yeah.
And the fact that we can sit here, because you and I come from things from different angles, we can agree on a lot of things, and then the ultimate solution to those things we tend to disagree on.
Yeah.
But we could both sit there and look at that and go, "Hey, this was really bad." This is, you want to tear down an institution and especially trust in an institution. This is a good way to do it. And that this was a very, very bad thing as well as everything else that's going on. So I just find it interesting that one of the things that I very much like about the show is that, we try and look at everything and not just focus on the things that are most damaging or most helpful to our own political sides.
I do think, and I don't think I scoffed when I said that this guy's a hero. I don't think that. I think the Supreme Court operates very differently than every other branch of government, and I'm not sure that what this guy did was illegal, and I think that has to be made clear. And I'm not for any kind of legal investigation unless the Supreme Court asks for one, and if they ask for one, I think it should be taken seriously. There's been calls for the DOJ to get involved, and nobody's sure if a crime's been committed. The reason is because a lot of what Congress does is classified or top secret. It isn't in the judicial branch. The judicial branch is very different and operates differently. Now, there is a very important, they have to be able to deliberate. They have to be able to do so honestly with each other, and this dramatically undermines that. And we're going to talk about that because it cuts both ways. One of the things that for me, in addition to all of these other issues, something that I want to make sure we talk about tonight is certain privileges that I think every American must necessarily have. And I think that if there's an exception, that we already know what those exceptions are, and I can't fathom anything beyond that. When they wanted to interview Trump's translator when he was talking with Putin to see if Trump had maybe done something that was treasonous, I was vehemently against it. Now, this is, I detest Trump, and I wanted to see him removed from office at just about any cost. But one cost that is not bearable is to break the confidentiality of a translator. They cannot do their work, and no head of state can do their work if they think the translator could flip. And you don't know what the translator is going to say or do when you don't. So it's the same reason why I think that guards, Secret Service, should not be able to ever testify against the people they're protecting. It's why I think, especially the idea, Jesus, I can't believe I've already forgotten her name, but she was in Texas and she was turned in for violating the Texas abortion law. Your doctor should not be able to turn you in for a crime, period, end of discussion. Because if you're worried about that, then you're going to say, well, maybe they're going to report my pot plants or whatever. So I'm feeling really, really sick, and you don't go to the doctor and maybe don't get life-saving treatment. This is why Doctors Without Borders has such strict rules about what they can and cannot engage on, and those rules have to be unbreakable. There's any number of areas like that. A lawyer cannot, if you tell your lawyer you committed X, Y, and Z crimes, it doesn't matter how bad they are, your lawyer cannot tell anyone else. And there's really very good reasons for that. There are very good reasons why the Supreme Court really has to be able to have these deliberations in private. I'm not thrilled that it was broken. I will say I understand that it was broken. I don't know if I was in these shoes, I don't know how I would have acted. I think I probably would not have revealed it. I don't think that makes whoever revealed it a hero. I do understand it. I get it. And it's interesting because somebody had suggested it was Thomas's wife who revealed it, and I'm not as far off. I think there's at least a 40% chance that's who it was. If it was a conservative who revealed it, that's who it was. It was Thomas's wife. Otherwise, it was a liberal. But that's notwithstanding. I don't want to get too derailed. But I appreciate that as Andrew, and I hope. The facts are facts, and I think that that this is that it's the biggest leak in Supreme Court history, and that's really not insignificant. But I do like, Mitch McConnell somebody asked him about what he thinks about the abortion issue, and does he want to take credit for this, because since the Garland nomination and going all the way back, this has been his end game. He's been playing this chess game for a very long time, and this has been exactly what he wanted. And they said, are you going to take credit for this now that? And he's like, well, I don't know why people are talking about the abortion issue. We should be talking about the biggest leak. And I was just like, oh, you don't know why people... Really? You don't know? Do you like it?
Yeah, that's what I mean about it. It's like, Republicans seem to be shying away from standing up and taking credit. I mean, because it's been in their platform for quite a while that they were, anti-abortion. They were pro-life. And why more of them aren't standing up and cheering this as a victory? Look what we handed to you, and even, God, I'm going to quote Bo again. Even he recognized that and was like, yeah, it's because the majority of people think that access to a majority of Americans, even Republicans, think that access to abortion should be legal. Now we quibble over where we draw the line. So, it's. To hear everybody on the right essentially just stomping around, most of the people on the right, just stomping around about how the leak was so bad and we need to get the Department of Justice involved and all of this stuff, and then not really commenting so much on the actual overturning of what the decision overturns, and then the people on the left are lauding the leaker like this was a really great, honorable and heroic thing for them to do, and I'm like, yeah, both of you guys are just freaking insane.
Well, the same thing kind of happened with Rittenhouse, who, again, we've had that discussion repeatedly. I'm not a fan of Rittenhouse. I don't like what he did. I really don't like what he did. I don't think he should have been allowed to do what he did. I think it should have been illegal. Just going there and carrying that gun. But when you take a look at the laws and say he wasn't a hero, the right was calling him a hero was insane. That people on the left were sitting there going, he went there to murder black people, which was said by multiple media platforms, very large ones. Like, whoo, that was
I think that's why. I think that's why we can actually get along and discuss topics and actually go at each other's arguments. I mean, we went after each other arguments over the specifically the abortion issue, which rights did Trump. And I specifically took a contrary position and tried to argue that position. I took the pro-life position. We should get rid of abortion in almost all instances, and because I really want to understand that argument, and I want to try and make the absolute strongest, best argument that I possibly can. And the reason that I think that we can do that is because we're both willing to recognize, when our own sides are doing shitty things. It's like I did not agree whatsoever that he was a hero. I believe that he acted in self-defense. Everything he did was legal and has been court adjudicated as everything he did being legal. And you also talked about, how he went there to murder black people. And we can both look at what our own side is saying and say, yeah, that is not true at all. It's like, because I agree with you that he shouldn't have been there. I also agree that the law probably should have been a little bit better written, so that he wasn't legally allowed to carry
Yeah,
a
he used a
rifle to a
loophole.
frickin',
He used a loophole
Yeah.
to get that guy. Yeah.
yes, exactly. And we can agree on those kinds of things. I think that's why we can have, good discussions about things, because we'll at least be honest.
I very much agree, and I really, and you often find interesting ways of challenging my views. But so, again, anyone else wants to join in, give us a call. The number is down at the bottom. I'll repeat it again probably a little later, or just live.intimeshow.com. Come on in and join us. Well, I do want to get back to this, because this is, for me, what I found most stunning. Based on how we've framed this and discussed this so far, I think Alito could have made a very good argument for overturning Roe v. Wade based on the fact that it was not a privacy issue. And again, to be clear, based on what I've said, I'm not suggesting that choice that women don't have a right to choice. What I am suggesting is that the argument that was used seems to have, in my view, been faulty. Overturning it may still not have been a great idea because of all these other problems. You made an argument for why it would have to be overturned at some point anyway, and then put in the right reasoning. But all that notwithstanding, he could have done that. That is part of what he did in this decision, but it's actually a very small part of what he did in this decision. What he did in this decision is really fascinating. What he did in this decision was say, okay, it was flawed because it's not a privacy issue. I think he's probably right on that. Then he dismantled the notion of privacy as it's been established since then. Wait a minute. If this isn't a privacy issue, why dismantle privacy? He argues repeatedly, and so he mentions, and what I want to discuss a bit is the difference between enumerated rights and non-enumerated rights, rights that we actually do have, but aren't specifically in the Constitution. How do you know, if it's not in the Constitution, how do we know that it's a right? And this has been decided by precedent, and we'll get into some of the precedents that have decided that. But usually the consensus is it should actually be determined as liberally as possible. And the reason is we are a free country. So if we're a free country, it should always be, the general principle that we've gone by is it should always be better to grant more rights than to take rights away. Basic principle of any free country. However, there is precedent that says you really shouldn't do it that way. We'll get into the precedent. He relied very heavily on that precedent and set this up so that this decision could be used to undermine any of the non-enumerated rights that rely on, I think it's the 10th, the 9th, and the 6th, I want to say. I'll have to think about that to try to, my brain is still a little mushy. But, he didn't have to do any of that. And the 4th. He didn't have to do any of that. He makes he's a Supreme Court, he actually could come up with a terrible reason. He doesn't have to even have a good reason. They can decide, the only reason they write these down is so that people know how, because we're based on, our common law is based on precedent. It's based on what other judges have said in the past, and you add up all that precedent into how are we going to act going forward. He is deliberately establishing precedent, but it's not precedent just to overturn Roe v. Wade, which he absolutely did, absolutely intended to do, and that's what's going to happen. But it's also precedent to overthrow everything. It largely that's not enumerated, but specifically privacy, and I think one other, I'll have to look it up, I marked all of these things. That's staggering. Because on one hand, he says Roe v. Wade is not a privacy issue, so we're throwing it out. Further, the privacy issues have been decided wrongly ever since Roe v. Wade anyway, and none of these privacy things that have been decided really exist. Why is that important? What are some rights that are not enumerated that are given either through privacy or through the 10th, which is the right to due process, or any of the other clauses we mentioned? Right to an attorney. That's not in the Constitution. We're going to go over the argument that he uses, but the argument that he uses clearly does not guarantee the right to an attorney. Now, that was decided in Gideon versus, I forget who, it's usually just called Gideon, so it may have been Gideon versus U.S., I don't think it was, but, what they decided there was that even though the right to an attorney is not enumerated, you have the right to an attorney because you can't have any of your other rights effectively protected unless you have an attorney. So the right to due process, which is the 10th, guarantees you the right to an attorney. we're gonna get into what this says and how it says it. But if you apply what it says and how it says it to the right to an attorney, he's saying you don't have that right either, or at least a state could take it away if they want to. Gay marriage, absolutely. And he's already gone down. He used this same argument when he wrote the dissenting opinion on gay marriage. He's already gone on the record saying that he believes you do not have a right to nobody has a right to gay marriage. It's just not a right. It is not a right. He went on that before this, but this now gives him the precedent to go forward with that using the same argument. Other rights. Right to vote. Constitution doesn't give you a right to vote. I said earlier about things that might be more important than Roe. Roe is obviously an extraordinarily important decision. But if you can't vote, and I'm not suggesting that he's going to take away the right to vote per se, but gerrymandering is one of, in my view, the greatest challenges to our rights that this country is facing. Gerrymandering and political action committees, the ability to buy off Congress. The only way to fix the ability to buy off Congress or any of the other problems we have, including Roe v. Wade, is to vote. Gerrymandering waters down your ability to vote, and in some cases really takes it away. And the only way you can get it back is going before the Supreme Court, before going to court, and it usually gets to the Supreme Court, and they have to decide. Now, sometimes we have a more liberal Supreme Court, and they decide in favor of overturning gerrymandering and making it easier for people to vote and have their votes properly counted, and sometimes they decide against it. This ruling, if it is enacted in roughly the same way that it is in this draft, could very easily be used as any kind of precedent for, in my view, now there's one or two counters to it. We're going to get to that. And if anybody, again, call in, we'll talk about it, or we'll talk about anything else. This is After Dark, so if you guys want to go on something else, I wanted to plant a few flags here. If people don't want to talk about it, we don't have to talk about it. But my read on this is that the standard that he applies obliterates almost every piece of progressive legislation since Roe v. Wade. It's staggering, and I understand why Roe v. Wade is what we're talking about. But just as I said earlier, and Roe v. Wade was the cornerstone to the granting of a great many rights that we now have, this decision could be the cornerstone in upending all of them, not just because that precedent was overturned, which he said shouldn't count, and we'll get into that, but because he very clearly goes after non-enumerated rights and makes the bar for having a right that isn't in the Constitution, like the right to vote, recognized. He sets that bar so high, I honestly can't think of any right that we have that arguably doesn't come in under that bar. That is stunning. That's absolutely stunning. So, Sister Porpoise, or the Constitution does give certain people a right to vote. Sort of. Not really. No. States have the right to vote. States vote, and they vote in something called the Electoral College, as we all know. States can pick their Electoral College votes any way they want to. They can put all the votes in two boxes, put the boxes in the bottom of an aquarium, and have an octopus pick it out. The states have the right to decide how they're going to apportion their votes. The Constitution guarantees the states the right to vote, not the people. The people do not have a right to vote according to the Constitution. Doesn't mean they can't vote, but they don't have that right. It has not been afforded to them. States, both because they've had some laws, many of them that have said that the governor, now the governor is the one in most states, I think, maybe in all, I'm not sure, who decides how the votes are apportioned. Many states have laws saying that the governor must apportion those based on how the state votes, how the citizens of that state vote. But those are laws that the states adopted. Not every state has that. Many of the governors do it only because it's tradition, and it never crossed their mind not to do it, not the least of which is they'd probably be murdered. But that notwithstanding, last I checked, because this was salient a couple of elections ago, because Donald Trump was calling up the governors and saying, you're not required by law to follow the state votes, not the citizens, which is true. So, the idea that you have a right to vote, despite the fact that it's not in the Constitution, is granted by Supreme Court decisions, which this undermines. And that I can tell it's absolutely deliberate. So this is a shocking document. Reuters did a similar piece as to what I'm saying on this. I've only seen one article in Reuters discussing this. All the rest that I've found really is discussing Roe v. Wade, which again, I don't want to sit there and say that that's not important. That's obviously extremely important for any number of reasons. I think this is much more shocking that way. Now, my hope and my suspicion is I'm starting to think that the person who leaked it, that's why they leaked it. Because leaking this isn't going to overturn the decision. In fact, I think it's correct. It's going to cement the decision for any number of reasons, again, we can discuss. I think it's going to cement the decision. But let me rephrase that. I think it's going to cement the vote. I don't think it's going to change the vote. I don't think Thomas or anybody's going to switch. So I think Roe v. Wade is going to be overturned. But this gives people enough time to do two things, which I think is why this was probably leaked. First, to mount serious challenges to anybody who's not supporting a legal a law to uphold Roe v. Wade. So this gives, by leaking it, we now have significantly more time to try to mount serious challenges to to not lose the Senate and any number of other things. We, the progressives or the liberals, and to get enough blowback on exactly what this says so that the decision gets limited much more to Roe v. Wade than it appears to be. There are decent arguments for why there's self-limiting language in this that would not permit the kind of thing that I'm talking about. Those arguments are wrong. Very wrong, and history has shown that, and we'll get into that. Again, give us a call if you want in on the conversation. If you have an opinion, I'll bring it up in the live chat. We'll be happy to answer it. Is there anything before we start to get into this decision, anything you want to say on that so far?
So far, a quick aside.
Please.
You keep mentioning the 10th Amendment. That is not the Due Process Clause. That would be the 5th Amendment. So stop saying the 10th Amendment. That's the States' Rights Amendment. And secondly, I would like to point out that, this was leaked, and so we read this, and it takes a very, very strong stand. And this was a draft version where, because they send, especially in the majority, they send the draft version around, and people put their input on it, and they finally come to a consensus on what's actually going to be in the final version. And if there's a justice that they just can't get on board with the decision, the drafted decision, then they'll end up writing their own. So this is a very early draft of the decision, and I think he was. This is a possibility. I'm not saying this is the case. That he's making the absolute strongest argument in the boldest language he possibly can, and that had this not been leaked at all, by the time we got the official decision released, that it probably would have been a hell of a lot more mild than what it is now.
Well, let me.
But we'll never know because.
Yeah. Well, let me find some middle ground. I'm not going to say probably, but I think there is a distinct possibility of what you're saying. I think that can't be ignored, which is that the other justices hadn't weighed in on this. Now, my argument is he's got some idea of what they're going to say and think, and the only one whose views I think differ significantly from this, that they would offer serious pushback, would be Roberts. Who, again, hadn't voted. But you're right, it's impossible to know because this was a first draft. Now, a first draft, I think there probably is a little bit of a kind of a wish list to it, but it doesn't go so far afield that people are going to sit there and say, we're never giving you first drafts again. They let the person draft this who they think is going to best represent the court and be able to get that done. So I think you're not wrong that it could have been watered down in the final version, and it's not unrealistic to think. I mean, I think that's a distinct possibility, and there's no way to know. I think that's very much worth mentioning. So I appreciate you bringing that up. I think you're right. It absolutely could have been I don't think he thought this was too far afield, but he probably had some wish list items on here that were going to get knocked down. So what they were, I don't know. But good. That's an excellent point. So thank you for bringing that up. All right. So
yeah. So it's just difficult because we're not ever going to know, because even though, if they do hand down the final decision and it is watered down, are we going to know if it's watered down because of public opinion, which I dearly hope it's not, because our highest courts shouldn't be swayed by public opinion. They should be swayed by the law.
Yeah.
And then if public opinion is strong enough against or for some sort of law, then they should be going to their representatives to get those laws passed, or to get those laws changed or repealed. The courts shouldn't be subject to, and this is one of the reasons why deliberations are done in secret and things like this, is you don't want public opinion to be swaying court decisions at all. That's a horrible idea. I mean, that's the French Revolution. So we don't want to be doing that.
yeah, I'm muted, of course. By the way, that was I very, very strongly agree with that. And there was a lot made by, too, where I think it was Thomas or somebody who I think is bordering on despicable, quite frankly, had said, we can't allow public opinion to sway us, and people have gotten upset about that. He's like, well, no, he's right about that. He's absolutely right about that, and that's so important. That's why they have a life term. That's why they have a life term, so that they never have to run again, so that they don't have to worry about public opinion. You can impeach them. It ain't easy to do, but you can do it. But, well, no, you can't. Actually, Congress can do it. You can't. And the reason is so that they are immune to political influence. In theory, they aren't immune to it. Obviously, they're human beings, but they are about as immune as you can be in our system, and that's why they get the lifetime appointment. And there are very good reasons for that, and we can discuss that a bit more in depth, but that is, I very strongly concur with you in that, and I think there are plenty of good reasons to slam what some of these justices have said, but the ones who have come out and said, we're not going to take public opinion into account, yeah, they shouldn't. And anybody who knows anything about the court, which probably includes whoever leaked this, knows that. Should know that. I'd be surprised if they didn't. I don't know how you'd get your hands on this if you weren't very close to the court, which means you have some idea of how the court operates, which means you're pretty aware that this isn't going to flip their votes. It may cement their votes, so that's a good argument for this being released for cementing their votes. I think it's much more likely it was released so that momentum can start to build against it, and it might get watered down, which I think is a distinct possibility. All right, this is the part that concerns...
Yeah, and we won't be able to tell.
No, yeah.
Oh, yeah, we won't be able to tell because are they really that immune to? You hope they are. Are they really that immune? But so if we get a more watered down version of a final, decision officially released, people are going to look around, look at what happens when you leak this stuff. At least we were able to pare back this draconian language and all this stuff, or that could have happened quite naturally had this never leaked, and we won't be able to know the difference. But everybody's going to make their own judgments, and I fear that it's going to encourage these kinds of things more often. And I hope I'm wrong on that.
I've forgotten Clarence Thomas's wife's name, but somebody had suggested to me that maybe she leaked it. And at first it's like, oh, come on, the wife of a... It's like, you know what? That's actually not a bad... Because she's that kind of... She doesn't think before she acts, and she does cray-cray stuff. I'm honestly... I would put... I have to believe the chance that she's the leaker is at least at 40%. I think it was probably a liberal, but if it wasn't a liberal, it was her. And she just didn't... I mean, she's in huge trouble if it was her. But all right. So let's see. So let's get into what I found most kind of interesting about this. So again, we talked about he really had. First of all, I mean, keep in mind, once the decision's made, he can come up with the worst reasons for it, and it happens on occasion where a judge just, they're not giving the right reasons or the reasons they really believe. They're giving reasons probably for political reasons, and it's horse shit. But they can say whatever they want. And again, unless they break their oath, there isn't a heck of a lot you can do. Judges have extreme power in a very narrow field. So not very narrow, but narrow. At any rate, but instead of just overturning Roe, which he did. He was crystal clear about his opinion about Roe. And he was crystal clear he's had that opinion since day one. And he wasn't listening. All the judges who say, we all know they're full of shit anyway. When a judge says, hey, we wait until we hear the case before we make it, doesn't work that way. And it really couldn't work that way. They're telling you what you want to hear. They're telling you, but, we all know that on a lot of these, they know exactly how they're going to decide beforehand. And it's not unfair, and that's why liberals try to appoint liberal justices. There's a perspective that they're going to apply already, and there isn't very much new under the sun. They know what's coming. But for anyone who doubts that, it's clear Alito knew what he was going to decide 20 years ago. He's like, if I ever get on the Supreme Court, I know what I'm going to do. He makes that pretty clear, too. At any rate, okay, the Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. In principle, depending on how you define implicit, he's reasonably accurate on that. The due process clause of the 14th Amendment. I don't know why I got stuck on the 10th, but yeah.
Due process clause is the 5th.
Of the due process clause of the 14th Amendment. So, okay. Yeah, it's the clause of. So that's what. And I somehow in my head, my brain is still iffy. Well, there's been arguments made that it always was, so it's not a new thing. At any rate, okay, this is the part that I want people to think about. Page 5 of the opinion, that provision, this is the due process clause of the 14th Amendment, which is that's the ERA, so I don't know. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must, quote, be deeply rooted in this nation's history and tradition and, quote, implicit in the concept of ordered liberty. Now, that implicit in the concept of ordered liberty, the fact that the word ordered there changes the definition of what he's saying from what one might think. He's not talking about liberty. He's talking about ordered liberty. That's a different thing. So it's not that it's implicit in the concept of us being free. It's implicit in the concept of those freedoms not causing chaos. So believe it or not, what he's actually saying is implicit. It's needed in order to maintain order. It's, and he gives examples and we'll get into it, but that's not quite what you think it is when you hear the concept of ordered liberty. Deeply rooted in this nation's history and tradition. Now, what's interesting is he used those words in his dissent on the gay marriage decision. And what he said was a gay marriage is not deeply rooted in our traditions, which is obviously true. But times change, and what is deeply rooted in our traditions, in fact, what is almost uniquely an American concept, is marrying the person you want to marry. The vast majority of human interaction and human cultures on this planet, weddings have been arranged. They're all arranged basically in the Bible for the most part. They've been arranged, they're still arranged quite often in India. The U.S. is an outlier in that. The idea that you can marry who you want to, so long as they're a consenting adult. That's the bar. That's the bar. The fact that the Founding Fathers couldn't conceive of what gay marriage was, they really, how well they could or couldn't. I'm not a historian. I don't know where they were these topics. Probably not very, because if you came out as gay, you were probably going to get killed. He's right. Gay marriage has no precedent, really, in the U.S. But, wow. So we talk about scope. And so the question is, what's the scope of the right we're talking about? The right we are talking about is the right to marry whom you choose. That is one of the greatest of American traditions. It's really something that we have contributed more to than most other countries, really. That is a broader scope. The narrow scope is, well, how many times has any of the founding fathers ever talked about, give me a break. Give me a break. But this is important because that's the argument he makes. So, deeply rooted in this nation's history and tradition, and, quote, implicit in the concept of ordered liberty. Here's the other thing. It has to clear both those bars. So even if there is something we have always thought of as a right, even though it's not in the Constitution, it's been in our traditions since our founding. Even if that's the case, if it is not implicit in the concept of ordered liberty, doesn't count. That bar is so unbelievably high. What are your thoughts on that, Xander? Am I taking this too far? Or, I mean...
It's certainly, I mean, you have to be a lot more legally astute. This is one of the areas that was brought to my attention because I didn't understand, or didn't grasp the significance of that simple little word, ordered liberty.
Uh-huh.
So I believe that you have a very good cause to be concerned with trying to set a bar like that, because it can be used to swat down so many things that we take for granted and have taken for granted for a very long time, since the founding of the country, for that matter. So no, I don't think that you're out of line raising that objection and pointing out that this could be a very, very bad thing to allow. That we need to be very, very careful about that because, even like I said, I'm not a huge legal scholar. It's like I get steeped in the legalese of everything. I missed that entirely. Like when I first read that, it was like, kind of the only thing that really stood out to me was the fact that, it's steeped in our own tradition and, liberty. And I was like, well, I kind of missed that very important thing that you just pointed out. So yeah, it's not unwise to be pointing out that this could lead to a bar that many of our rights that we enjoy won't be able to meet.
It's very hard to find one that isn't enumerated that crosses both of those. I can find plenty that cross one or the other, but that crosses both, inarguably. There are a few that cross both, but it's arguable. And what's key here is what he's setting up, and I want to actually try to find this line again, but I moved on, so I think that was that page 5? I want to find that again, because the other thing is, that actually comes from, he didn't invent that language. That language is another precedent. So he's actually relying on the Washington versus Glucksberg precedent that was 1997. And that precedent obviously hadn't been used very much until then, hasn't been always used since then. And what he is doing in this is cementing that as the precedent that should be used going forward. If that's the case, that changes absolutely everything. And like I said, there are rights, and we're going to get into a few of these. There's a whole bunch of rights that I was thinking about where I'm sitting there going like, is anybody really going to challenge interracial marriage? And I don't think right away, but I think somebody in Texas is going to do it. And all it takes is some idiot who really wants to cause trouble, who's really trying to make a statement, and it takes him appealing it all the way to the Supreme Court, and the Supreme Court being willing to listen. Now, what the claim here is, and this is what's really fascinating, this is one of the reasons I actually really appreciate having you on the show. There's a lot of fawning over each other on this show, which I still think is usually a pretty good idea. But I want to point this out. When you and I first started talking, I was very troubled by your talking about all of these rights that we really didn't have. And one of the things that you got me to understand through some discussion was, it's not that you thought that any of these were things that we shouldn't do, but you really felt that it should be left to the states, which is what I hear a lot from conservatives who are trying to really fuck me and people I care about over. So I get triggered when I hear that. We should leave it to the states. And Alito has no interest in leaving this to the states. He's got none. That's the argument he makes here. The entire argument here is it should be left to the states, and he explains why, and he considers himself a hero in this decision because he ends with, what I am doing, I am giving up the judicial authority over this. This isn't for judges to decide. It's for the people to decide. You decide through your legislators and they legislate this. No, this is the first step in making it illegal nationwide. That is his goal. I think that's the goal for the most part of everybody who said, yes, they want to make it illegal. They can't just jump to that. So they're going to kick it back to the states, and then they're going to wait until somebody comes up with something else where they can then make it illegal, just nationwide. That's my view. I think that's an easily defensible position. So I am very suspicious of anybody who says, well, we should let the states decide, because for me, that is code for we're going to get rid of it. It isn't for you. And you had made some great arguments. I think the one that really convinced me was when you were talking about welfare programs. And you were like, the government shouldn't be doing welfare programs. I was like, dude, how the fuck are we going to, people need help. He goes, yeah, so the states should do it. And you came up with all of these great examples of welfare programs that work great for a lot of states, but then don't work for some states. Really don't, for very specific reasons that are obvious. And obviously, California is going to have a different kind of homeless problem than Boston for a number of obvious reasons. And if you sit there and you try to create one program that's going to address and say you have to give a specific amount to housing or this or that, they're different problems. And so I was like, okay. And then you came up with all sorts of other issues. And I said, okay, I'm starting to see how and why, so long as the states actually do it, and this isn't an excuse to toss it, and it isn't with you, which is one reason why I've really enjoyed having these discussions with you. And I've sort of learned to like, oh shit, when Zandering says something, he's really being honest about it. I find that disconcerting, speaking to a conservative who means what he says. It's really, I'm still not entirely comfortable with it, but okay. I should probably stop with even the joking backhanded compliments like that. But anyways, yeah, sorry, please continue.
Well, but and Titan just brought this up because I was thinking about the same thing. It's like the same time you're talking about, this should be put up in the states. And the issue that I have concerning this particular, because I actually don't believe that this is a states' right issue. Abortion is not a states' right issue. And essentially what you're trying to say is that the individual states, the residents of the individual states, get to decide on what is considered a right. And states can expand upon rights, but they can't limit them. The federal, the federal Constitution, the federal government guarantees, the citizens of the states certain unalienable rights. And I believe that bodily autonomy, just like the right to life, liberty, pursuit of happiness, all of the enumerated rights that are actually in the Constitution and its subsequent amendments, that these should be federally protected so that states cannot violate them. So when it comes to specifically the abortion issue, and the only reason that I changed my mind was the bodily autonomy argument. It's the only one that I find it to be compelling in any way as far as pro-abortion. And that comes down to every individual in this country has that right. This is a federal issue. This is a right that should be protected, guaranteed by the federal government. And it's not often that you hear me say that there are things that I think that the federal government should be doing. This is one of those instances where it's guaranteeing fundamental human rights. I believe that every individual in this country has the right to bodily autonomy. You have the right to decide if your body will be used by some other individual. You have that right. And I don't believe that a majority of people or a very active minority of people in a state should be able to strip individuals of individual rights. So I don't like that he just, it's going to get kicked back to the states regardless. But I don't like the way that they overturned Roe versus Wade in this, because they could have very easily said that Roe was very poorly reasoned, that they recognize the courts recognized the right of bodily autonomy, and they could have, in one fell swoop, overturned Roe versus Wade as a precedent, and they, in the same decision, because this was an abortion case that was brought before them, and it enshrined the individual's right to bodily autonomy, legalizing abortions forever. And they didn't do that. They just overturned Roe and said that that this was poorly reasoned, which crumbles the basis for several other kind of personal choices that you would make. So, I don't like the way that they did it.
Well, and Porpoise had mentioned Casey too, which is mentioned in this on a couple of occasions, as is bodily autonomy. Actually, I think bodily autonomy is only mentioned twice in this, and both times are very dismissive. It's just sort of like, well, bodily autonomy doesn't really count. Here's why. Moving on. So this focuses entirely on Roe. Really doesn't get it too much into Casey, which had different reasoning. I don't. This is a hit job. This is a hit job on Roe. It's also a hit job on, I think. So here's how this pans out, I think. Going forward. Now, so there is an important line. I think it's really about time I've gotten to this because I keep referencing it. One of the things that he does say is, okay, so on page 62, quote, "And to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to an abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." All right, that's actually reasonably strong. But that represents a quarter of a paragraph on one page in a decision that the actual decision, the arguing of that decision, is over 60 pages. And the arguments that he gives overturning the rights to privacy, generally, he doesn't say that there's no such thing as a right to privacy. He does explicitly say, this is interesting because he goes out of his way to explicitly remind people that the right to privacy isn't in the Constitution. True. But it's interesting that he went out of his way to make sure that he planted that flag very early on, and then said, okay, here's how it's been made larger and larger and larger inappropriately, and what he calls legislating from the bench. And he describes why Roe was actually much more like legislation than a decision, and he actually makes a very good argument for that. Doesn't mean you overturn it, but he made some interesting points. It's like, that's an interesting point. I'm not sure I disagree with that point in particular. It doesn't mean you overturn it, but okay. One or two of his arguments are reasonably well reasoned. Having said that, he then goes on to explain why all privacy rights have been really misapplied since Roe, even essentially before Roe, and that the rights must follow this much more narrow view. If Roe isn't a privacy issue, why is he saying that? If Roe isn't a privacy issue, he doesn't need to say any of that. He is putting that stamp as precedent. Now, anybody can go before the court and say, yeah, but in that precedent, they said that to ensure that our decision is not misunderstood or characterized, we emphasize that, so you can't use this as precedent. But the problem is he's done 60 pages of arguing why this applies to any kind of privacy right. That's the entire argument he's making for the vast majority of this case. So people can still reference that argument, and they can say, yeah, we're not talking about what he's precluded here. We're talking about how he said that specifically privacy rights are to be determined in the future. And the reality is that kind of thing happens all the time. Well, what happens all the time is ignoring specific injunctions against particular things. Now, the most obvious one is going to the Gore v. Bush decision, which was, in my view, so atrocious that they literally had to say, don't ever use this decision for precedent on anything ever going forward in the future. That's what they said. For the most part, to the best of my knowledge, that's been largely adhered to. But the reason was because the scope of that was so narrow. The scope of this is not narrow. This doesn't apply to anybody who's trying to become president of the United States. This applies to at least 50% of the population in this country. That this isn't narrow, and privacy isn't narrow. It's remarkable. Anyways, so I do want to, and I highlighted it. I'm going to put it up here because I want to be very fair and I want to make it crystal clear that this is the arguments that I've been making. This is that one paragraph. It's not even a. Look at that. I've highlighted that. That is the part that reads exactly what I just said. So that's what 2 or 3 sentences in a over 60-page decision. And those sentences say, we want to make sure that you're aware that this applies just to Roe v. Wade. You cannot do that. And in fact, he explains in the very beginning why you can't do that, because he's also talking about the importance of precedent and what happens when you overturn precedent. And he's very clear about that. So he's talking out of both sides of his mouth in this decision. Anyways, so here's the question. Take anything that's been decided on the 14th Amendment, which is a lot of stuff. Roe v. Wade is one of them. Absolutely one of the bigger ones. Aside from the right to vote, it's probably the biggest. Take a look at that and ask yourself, okay, of every decision that has ever relied on the 14th Amendment, which ones arguably, we don't have to have it black or white here, but arguably do not meet the dual bars of being a part of ordered freedom and part of our a long history of tradition in the U.S. If it doesn't fit both of those, and in the most narrow interpretations of both of those, and he's made that crystal clear, it is now back on the table, period, end of discussion. That is, for the most part, every single progressive decision in at least the last 50 years. That cannot be by accident. Alito is not stupid. And this is actually very well written. He knew exactly what he was saying here, and he knows the import of it. I can't, and like I said, I mean, oh, wow. That's my read on the decision. 1-800, not 1-800, Jesus. I was thinking of getting an 800 number, but, it's free if you have free local caller. Get a 900 number. Get a 900. Xandring will. Okay. So can you read the Constitution and just get a nice low, just read the preamble to the Constitution or something like that, and we'll just so we'll get a 900 number, and Xandring will read the Constitution to you in just this really low voice. So it's 1-484. What?
Press 1 for the Constitution. Press 2 if you want to hear the Declaration of Independence. Press 3 for the First Amendment. Press 4 for the Second Amendment. Now, of course, when you hit the 14th Amendment, you have to have 5 different buttons for that, because there's 5 sections. That's a long, big-ass amendment. That does so much stuff.
All right, so it's 484-246-8463. Yes, please. There's an interesting...
Yeah. Oh, yeah. Do the number.
And
it's interesting when he's talking about things like privacy issues. Because there's some. You had brought this up in our little discussion about looking at the vying 2 rights and which one should hold precedent: the right to life or the right to bodily autonomy.
Yes.
And you had pointed out that there are certain rights that are understood to be had because they de facto must exist in order for an enumerated right to exist. The Fourth Amendment is an example of this for privacy. The Fourth Amendment starts off with the right of the people to be secure in their persons, houses, papers, and something else against unreasonable searches and seizures. Well, if you have that right, you must, by default, de facto, have the right to privacy. You have to have that. Otherwise, in order for this enumerated right to exist. And so you point out that there are certain rights that are, we call them enabling rights, I think, that enable an enumerated right. So I find it interesting that he's attacking the right to privacy, especially in the way that Roe was trying to use it, while at the same time, as you pointed out, he's saying, abortion isn't a privacy issue. Oh, by the way, let's go over all of these privacy issues, which is an enabling right. We know that we have the right to privacy because the Fourth Amendment exists, and we can't have the Fourth Amendment without a right to privacy. So, I agree with you. I think that this guy's not stupid, and that he's specifically trying to set the groundwork to make precedent for future decisions. And I wonder where exactly he's trying to go with that. Because you have to be very careful about those, when it comes to Supreme Court decisions, they're gone over with a fine-tooth comb. He knows that everything's gone over with a fine-tooth comb. So, anything that's put in a decision is there for a very specific reason. They're not just there to shoot the shit with you on any particular law. Everything is in there with malice of forethought. I hate to say malice of forethought, but it really kind of is.
That actually gets me. Yeah, okay. I want to address Andreas Wolf said something which I think is very important, and I want to get to in a second. I'm going to derail myself for a second, though. If you thought you were angry before, page 10 of this decision. Quote. The state's regulation of abortion. The state, in this case, what they actually mean is the United States, so the federal government. The regulation of abortion is not a sex-based classification, and thus is not subject to the, quote, heightened scrutiny that applies to such a classification. So what he's saying is, and then he actually goes on, so the medical procedure, it's a medical procedure. Yeah, the regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny under the regulation, unless the regulation is, quote, a mere pretext designed to affect an individual's discrimination against members of one sex or another. So what he's saying is, unless you are explicitly trying to use abortion to suppress women, unless that's your explicit desire, then it's not subject to greater scrutiny. And this has nothing to do with sex. Ergo, you cannot say it's a women's rights issue, and you cannot try to use any women's rights legislation, equality legislation, or anything like that to attempt to say that women are entitled to the right to an abortion because it puts them on equal footing. You cannot make that argument. So that's what he argues here. What I find interesting about that, well, there's a lot that's interesting about that, but it's self-defeating. The only way you could determine whether or not this was a decision made out of any form of sexism would be to give it that extra scrutiny and try to figure out it. Dear fucking Christ. Anyways, you thought you were pissed at Alito before, and it's just interesting because I was observing a live chat earlier where somebody had said it's a women's rights issue, and nobody corrected them. And I was just like, yeah, not according to, if this becomes precedent, and actually he's citing previous precedent. He's got previous precedent for that, but I'm just like, this is cute. At any rate, to take this back. Oh, yeah. So Andreas Wolf had said, so abortion is the only one that's, yeah. So what he said specifically about this, Rose, and this is the only other time it's mentioned, so twice in the entire decision he actually mentions why this applies only to abortion. The first is the paragraph that I wrote, that I read earlier. This is the second one. It's that line right there. So it's just like this tiny line. And what he says is, Roe's defenders characterized the right to abortion as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledge, because it destroys what those decisions called, quote, fetal life. So what he's arguing is the reason that this is different and that this decision does not apply to any of the others is because none of those destroy fetal life. The problem is that argument makes absolutely no sense, because if he had left it there, fine. If he left it there, okay, you can say that. But the problem is what he undermines later isn't saying that fetus has any rights. He never makes that argument. The argument he's making is that this is a states' rights issue. Why? Well, in part because it's so explosive and this and that. Okay, that fits with what he just said. But those are throwaway lines. He spends most of the time saying because we're not guaranteed the right to privacy. He doesn't argue. Well, he argues for a couple of lines that, the states have the right to decide whether or not the fetus has life and has rights and yada, yada, yada. And that coincides with the part of the argument that he just made there as to why this is a unique situation. But he attacks all of the situations equally when he's talking about why we do not have a right to privacy and that the right to privacy must be so narrowly interpreted. He didn't say it has to be narrowly interpreted in this case because this case has a fetus. He said it has to be narrowly interpreted in all cases, and he enumerates a great many cases where he said this was way too broad. This is legislating. Well, if that argument was too broad in all of these other cases, he can't then sit there and say this applies to only one case. And he can't be stupid enough to not know that. So that's the argument that's going to be made as well. The reality that, okay, we can sit there and say that part of the one part of the decision, yeah, just like he said, only applies to abortion. But the reality is the arguments that he's making, he clearly says applies to all privacy issues. And I quoted it. I can quote it again. He's like, okay, this is the bar. He's very clear. It's not the bar in this case. It's the bar in all issues of non-enumerated rights. Those rights must be, quote, deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty. All of them. Not just the ones that have a fetus. So this decision, in my view, is meant to do two things. One, allow all of these rights, and I was about to say to dramatically curtail these rights. I do think he wants to end abortion. I think he wants to do that at the federal level. So he's about to do, I think if it comes up to the U.S. Supreme Court, he's going to very strongly argue for abortion should be banned in this country. I think he's going to make that argument, which would he'd be fucking undermining the arguments that he made here. These arguments are for why it should go to the states. So, but having said that, all of these arguments, I think I lost my train of thought. He's not trying to curtail all the other rights. I think he will, many of them, not all of them. But what he is doing is saying that they're not actually rights and it's up to the states. And if the states wants to grant them, great. So he's not saying they can't be granted. He's just saying they're not de facto in the Constitution. So you don't have them unless your state wishes to grant them to you. It's a fine point. He's not explicitly, he's not trying to say you can't have an abortion. He's trying to say the state gets to decide, not the federal government, as to whether or not you have that freedom. It's no comfort in terms of if you live in a state that's going to outlaw it. But can that abortion isn't a sex-based right be used to favor trans rights? Well, that gets into a bunch of other arguments. I don't. It's very hard to see any non-enumerated right that isn't hit by this. The trans rights are absolutely going to be struck by this. Again, what he's going to do is he's going to kick it back to the states, presumably. I can't think of anything that, and with the states, the biggest problem is the people in power want to stay in power. So my biggest concern is the gerrymandering. And I've told this story before. I'll tell it again. I used to do this all the time. It's a risky move. 9 times out of 10, it worked beautifully. Usually when it worked was when I was with somebody who was new and had no idea what I was doing, and they got very nervous when I sat there. One thing you want to do if you're door knocking, you don't want to insult or undermine the views of the person you're talking to. I would do that all the time, but you have to do that very carefully. So I'd go up to someone and say, I want to talk to you about Barack Obama. I can talk to you for a few minutes. And we talk. And I'd say, what's your most important, what issues are most important to you? Well, gay rights. Say, yeah, no, that's not important at all. There's nothing about gay rights. Your views on gay rights are completely irrelevant. What's another view? And they would look at me like, oh my God, you're here just advocating, you're telling me my views are irrelevant? It's like, well, I say, what's another view? And on occasion, they'd hit me up with another view. Usually they'd be they'd stammer. They'd say, well, I think it's important. I was like, well, yeah, of course you do, but your view is worthless. And they're like, well, don't tell me my views are worthless. I can vote, and I'm going to vote for it. And I say, well, wait a minute. In order to successfully run for president, you need how many millions of dollars? And I had the figure at the time at the top of my head. Say, how many candidates do you know that have been bought off by political action committees? Do you think your views on guns has any effect when you're fighting the NRA? Do you think your view on guns is important? Because you may be right, whatever your view is. It might be the best view in the history of mankind. But do you know politicians that are going to hear it when the NRA can just buy them off? How many millions of dollars do you have so that your view can be heard? And that's, then they start thinking about that, like, oh, the average donation to Barack Obama is $75. Who do you think he's listening to? Who do you think he thinks is important? You want to vote in somebody who's beholden to corporations, who's beholden to, and there you go. And I made that argument. That's how you go with that. Now, there must have been some reason why I was getting into that story. I forget how and why. We'd been talking about trans rights. Shoot, I don't know. I'm getting tired, and it's hot in here.
I hate when I do that.
Well, and I'm doing that a lot more because I'm feverish.
I've got a point,
yeah.
And here's a story to illustrate it, and then I get into the story, and then I forget why I even started the story in the beginning.
Oh, well, something about
I do that a lot.
Yeah, I've been doing that more and more, especially now. It's probably like make a note, like what the point is before but it was. So I was talking about door knocking for Obama, but I do remember now. I would argue the same thing about any of these other things that we're talking about in gerrymandering. You think your views on abortion matter? Really? If you get gerrymandered into a district so that even though your state is 50% blue, sorry, not 50, sorry, it's like 80% blue, and we've seen this. We've seen states that are 80% blue, and yet 50% plus one red representation in Congress. That's gerrymandering. Your vote is either not being counted or is being diluted dramatically. So whatever your views are on all of these larger issues really isn't important if your right to vote isn't recognized. And my argument is, if your vote is watered down that way, your right to vote isn't being recognized. This obliterates your right to vote, in my view. Doesn't obliterate it. That's extreme. I think any challenge on the right to vote now, and any challenge to gerrymandered districts, a number of which have gone up before the Supreme Court, not all of them have been decided well, in my view. This precedent allows anybody to come up and argue and sit there and say, well, wait a minute, the right to vote isn't in the Constitution, which it's not, and the right to vote for president per se isn't long-standing tradition. It's the right to vote for electors, which is. And if that sounds unreasonably narrow, okay, but that's the exact same argument that he used in gay marriage, saying, well, the right to marry who you want to, sure, we've had that, but so long as they weren't of the same sex. That's new. So since that's not part of the tradition, that's not a right. Utterly unhinged, utterly insane, narrow beyond all usability, obviously biased. Obviously, this is a problem in terms of Roe v. Wade. Obviously, this is something that has to be addressed immediately in terms of Roe v. Wade. So I do not want to detract from the damage that this has done with Roe. The problem is, and all of this looks deliberate. I read the language in this, and I read how he constructed it, and to me, it looks like it was constructed to undermine all of these things that we've been talking about deliberately, to give him and the court power to use this explicitly, even though it says you can't, to use it as a precedent to undermine any of this other legislation going forward, if it ever comes back to the Supreme Court, which it will. Now, is this reasonable? In my view, no, but the reality is, if the court is made up of the same people that are in it now, the decisions that we get are going to be in line with this one. So it strikes me. Now, there aren't a lot of channels talking about this. There aren't a lot of people talking about this. Like I said, I found one Reuters article talking about this and had almost identically the view that I'm sharing now. It was one article on Reuters. That's it. I found a few people who have said, well, there are people who are worried that this, but he takes care of that. Somebody asked me what percentage that was of the entire document. I mean, that's 4 sentences out of a 60-page document, and you figure it out. No, and typically you can get around stuff like that depending on how it's worded. I am an amateur at this. I'm a good amateur. I've taught law. I've done mock trial. Been around lawyers my entire life, and I've been on lawyer commentary shows. I am not a lawyer, and this really probably needs a very good professional with a good eye at this kind of thing to really look at it. And I don't know what they're saying. I haven't heard a lot of that recently. Everybody's upset about Roe, as well they should be, or the leak. But in my view, and again, I go back to what I said at the beginning. The Roe decision, I don't think anybody really anticipated how many rights would flow from that and the right to privacy that it really enshrined. Rightly or wrongly, in terms of how it was decided, that's what it enshrined, and a lot of rights that I think we absolutely must have flowed from that. All of that is on the table now. And it looks to me like that was deliberate. And it looks to me like he gave himself some cover with some throwaway lines that you can easily get around if you're a lawyer and you know what you're doing. To the layman, that paragraph that I read, this decision... wait a minute. The provision has been held to guarantee the same rights not mentioned. No. The one that I'd read earlier that basically said you can't apply this decision to anything else. No. That doesn't. That's going to be up to the judge as to how narrowly or broadly that can be determined. And if it's going before the Supreme Court, I got some hints now by reading this as to how that's going to be interpreted if somebody tries to argue that to him. Because this is now precedent for future Supreme Court cases. We talked about echo chambers, and this was. I'll let you talk. I'm sorry. I know I've been ranting. It's just, and again, like I said, I haven't heard a lot of support for this. So maybe I'm off on the deep end. I don't think so. But we talked about echo chambers where somebody on Fox News, a pundit who is not a reporter, will say, well, I'm thinking X, Y, and Z. They don't have to support it. They don't have to cite sources. They're not a reporter. But then a reporter later on says, well, people have said. Yeah, somebody else on Fox News, and they said it so that the reporter could accurately say that people have said. But it's not, and so they set up these echo chambers where they can invent their own news. This is an echo chamber. This is designed to be precedent for future Supreme Court decisions. And they're going to sit there and say, well, Alito said this, this, and this, and he's got 1,000 outs in that. That's my view on it. It's. I think this is, and so if Roe v. Wade, which wasn't designed to be one of the cornerstone pieces of legislation in the last 50 years, but has turned into that, what do you think is going to happen with something that is designed that way? Anyways, that's my view, and it's stunning. I don't know. I think it's probably about time to start wrapping this up. I appreciate it. We've had people sticking with it, but I don't know. Any thoughts, Zandring?
You do keep mentioning that the Constitution doesn't give voting rights, doesn't give you the right to vote. I disagree with you. Because amendments to the Constitution are part of the Constitution, and both the 14th and the 15th Amendments both give a right to vote. The 14th Amendment prohibiting states from denying the right to vote to any male over the age of 21 that is a U.S. citizen, and the 15th Amendment, which specifically states that the United States shall not, or the right of the citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. Of course, the 14th Amendment doesn't apply to Indians not taxed, so I guess you're just screwed if you live on a reservation and you're an Indian because you don't have the right to vote. But the 15th Amendment clearly states the right of the people to vote shall not be infringed based on color, race, previous conditions of servitude, etc.
Okay, but okay. So as long as it's not based on that, so as long as they're all being treated equally, it can be. So so how would this
No,
preclude, for example, gerrymandering?
Well, yeah, I guess.
What it's saying is you can't be discriminated against. You can't have your right to vote taken away because you're black or because you're a female. That's what that's saying. So I agree with you.
But if you take away everybody's right to vote,
if you don't discriminate, as long as you're not discriminatory, that's the whole point of the ERA, the Equal Rights Amendment. You have to treat everybody the same. That's what that says. Now, You're right though. If I say now the 14th, I got to look into. I think you're right because and I remember the 14th, and that was because of the Vietnam War, the draft, and the okay. No, that wasn't why they put that in. I'm trying to. Oh, yeah, I'm starting to fade. But you're right. I don't think. I don't. Well, let me just correct. Let me just listen. I'm trying to say you're right, and I want to get that out and done and forget about it as rapidly as possible. Okay. So I know you want me to keep repeating myself, but please. No, you're right. I can't say that the Constitution doesn't guarantee the right to vote because at least in part it does. You're absolutely correct. So saying that it doesn't is inaccurate. I'm wrong about that. I still think it doesn't guarantee it in the sense that I'm trying to use it here, but I think you are correct. I think it at least guarantees it to some extent. And I'd have to look at how it is in the 14th, but in the 15th, it applies to you cannot deny it based on. And since we do know that felons can have their right to vote taken from them, I have to believe it's not as strong a right as I don't think it's a guaranteed right in the same way as we usually think of rights. But there are other rights that are taken away from felons as well. Yeah.
Right. There is the due process clause of, because the 14th Amendment is huge. It's like the biggest amendment we have. There is in the first part of it, towards the end of it, it reiterates the Fifth Amendment, essentially is what it does. So I'm not sure why they stuck that in there, because it literally just almost verbatim repeats the Fifth Amendment, which is, you can't have any of your rights taken away from you without due process of law. So as long, a felon has gone through due process of law and has lost certain rights.
Yes.
And they did so with due process of law. So that's how they justify taking away your rights. And I believe that once you have served your term, served your time, you're not on. If you're completely finished, like I'm not on probation anymore, I'm not any of that stuff. Your rights, all of your rights, should be reinstated, with one possible exception. And this one's a difficult one to wrangle through on principle, though the practical effects seem to make it pretty simple. Violent felons that are in prison because they did violent things shouldn't necessarily have their rights to own firearms restored. But it's like I said, that one's a hard one to get, to argue completely on principle alone. So, but obviously it's like, okay, well, you have a mass murderer. We got life in prison, managed to live long enough that he got out on parole and actually finished his time. Maybe he's 90 now, but he did manage to get out. You want him to be able to go buy a gun again. It's like, yeah, that's probably not a good idea. But there's some instances too, like I have a. Go ahead.
No, well, please say that one. The sound you heard was me. I've closed the phone line because I can start to wrap it up. So, but please finish.
So yeah, it can be difficult, but yeah, due process does still apply in two different parts of the Constitution. But yeah, people are like, and I fall victim to this sometimes too. So because I don't have every amendment memorized. It's like I have certain ones memorized, because those are kind of the important ones. I hate to say those are the important ones because they're, but the prohibition and the repeal of that amendment, they aren't important, other than historically interesting. But they're not important. Who cares if anybody knows about it at all? So I just try and remember what it is, but I fall victim to it's like, well, the Constitution doesn't say that, and it's like, because I've read the Constitution so many times. It's like, I'm pretty sure that's not in the Constitution, except that all of the amendments to the Constitution are part of the Constitution.
Yeah, absolutely.
I mean, we can
Absolutely.
change it. So they have to be taken, they are part of the Constitution now. We changed it. And there's some of the things that, there's been several constitutional amendments that I believe should be pursued vigorously.
Oh, I do want to point out, so in Florida, and I remember this became relevant for any number of reasons, in Florida, you have to actually, you have to petition the governor to get your right to vote reinstated after you're a felon. You don't get it back. You have to petition the governor, and he has to hear each petition individually, and I think in a 4-year period, he restored something like 37, not even, and there's a whole bunch of it. I think it still goes state by state, but on the whole, I think you're absolutely correct. I can't sit there and say it doesn't guarantee the right to vote, because that's just not accurate. So I'm gonna have to fine tune what I'm saying there, because you're correct. So that's a worthwhile correction. So thank you.
Also, I'd like to point out that the 14th Amendment prohibits you being able to deny the right to vote to any person, any male. Let me rephrase that: any male U.S. citizen over the age of 21. You cannot prohibit their right to vote. And then the 15th Amendment goes on to say that you can't, the right of the people.
So that it essentially amends that one to say that you cannot discriminate against. So it would presumably then apply to everybody. So I do want to know then, how is it that states can take away and not get you that right back, or even just take them away based off? There's got to be something we're missing. There's a precedent somewhere or something like that, but I'm not going to do a deep dive into it now.
Court cases on there, but it's it's due process to take them away. It doesn't say that you have to reinstate them, because you went through due process to remove them. It doesn't say anything about that you have to reinstate them. So, you did go through due process. You were stripped of these specific rights, and then it's up to the state whether or not they're going to grant you your rights back, which I think is ridiculous. You should, it's like, if I'm no longer, it's like I paid the penalty for the crime I committed, I'm still a member of society now in good standing. I should have all of my rights.
Yeah, I couldn't agree more. All right. Well,
again, several amendments I think that should be pursued vigorously, because and changing the Second Amendment. I've already stated several times that the Second Amendment should have been amended after World War I, and absolutely after World War II, because we ended up with weapons that can do massive damage and huge casualties, and that should have been, because
it obviously
take a strictest reading of the the Second Amendment. It's like, well, Congress can't, shall not be infringed. It's very, very clear. So, and there are certain weapons that absolutely should be infringed upon. I think we can all agree that we should be able to own private nuclear weapons.
All right. So before we go, we do have, thank you, Titan, and this came in actually quite some time ago, but I got distracted. From the Associated Press, quote, the Supreme Court's 9 justices met in private for the first time since the leak of a draft opinion that would overrule Roe v. Wade. The court offered no word on what was discussed, other than to indicate at least one decision will be announced Monday. I don't know what that means. This is last I heard. So what people forget is, and I forget it on occasion too, the draft isn't the only thing that was leaked. The Politico source for this also leaked some of what had been going on behind the scenes, including who voted for what, and that Roberts had as yet not voted. So this comes from a leak inside the Supreme Court. Now, that leak said that the decision was scheduled to come out, if I recall, it was July. So, and then last that we have heard, July is still the timetable for this, presumably since they're not supposed to cow to political pressures. This actually should not have any effect on, do not give David Thompson nukes. I'm just saying. He does, no nukes. I'm just saying. Not anyone, but him in particular. If for no other reason than he knows my address. At any rate, So the last I heard, it's supposed to
with
be
a
July.
nuclear
So,
weapon,
yeah,
with a nuclear weapon, you don't really need to know your address. You just need
That's a
to
good
know
point.
the general location of the United States that you live in.
yeah, I suppose that's pretty fair. As long as he's got me within a 50-mile radius. All right. So, all right. Well, I guess Monday may be an interesting day. We'll thank you, Titan, for that. We'll keep an eye on that. Yeah.
After the leak, I'm not entirely sure what the point of delaying the release of the decision, unless they haven't really finalized. They still need to be able to write more stuff, or whatever it is that they need to do to produce the finished official decision. But after this leak, I don't see much point in waiting that long unless they need it to write more stuff. But
well, that's ostensibly the only
like
reason.
it's already been leaked.
That's the only reason, ostensibly, they hold it that long in the first place. They're aware that every word they say is going to, every word they say is going to be poured over for generations. So they take months to write these decisions. It's a long, grueling process. So the timetable for when they're going to release the decision is, first of all, it's not actually set in stone. It's usually just an estimate. They don't know necessarily, although they've usually got a pretty good idea how long it will take them. But that timetable, ostensibly, the only thing that determines it is how long it takes to write the dissent and the majority opinion, and then any other opinions if anybody else wants to write them. So this shouldn't change the opinion. They didn't keep it. Presumably, it wasn't set to July for any other reason than that's how long it takes. Now, this was February 22nd that this first draft was written. I have to believe they have a second draft by now. But it takes a while to corral this stuff. So if they were able to, here's the problem. This is the same reason their hands are tied and they can't change the vote. If they were to come up with a decision on this on Monday, the first question everybody's going to ask is, well, wait a minute. How did you get it done this quickly? Why'd you have to wait till July if now that it's been leaked, you can release it 2 weeks later? Really? So I can't fathom that they're going to release this decision by then, because it's going to have the same problem if they change their vote. Someone's going to say, well, wait a minute, you're supposed to vote based on the law. What law has changed since the last time you voted on this? The answer is nothing. So why'd your vote change? Politics is the only answer they can give. So I can't fathom that they are going to release this on Monday. So I don't know what they're going to be releasing on Monday. A decision? I have no idea. Like I said, I think the only thing, my suspicion is that the hope was that by releasing this, that they could apply pressure to reduce the language, or to soften the language, I should say. But you brought up some interesting challenges to that, and there's no way to know. So, all right. Well, thank you all for hanging with us. It's been a very long show. I've been ranting most of the show, so I appreciate the leeway there. Any final thoughts, Xander? I think I already asked you that, but I want to ask you that again just to make sure that we're all caught up.
This is where the, I guess, ideal or the fundamental ideal versus real world consequences can come into conflict. Like I said, in 50 to 100 years, they may look back and say, yeah, overturning Roe was the right thing to do because it had faulty reasoning. And maybe it is, maybe it isn't, but real people are probably going to suffer because of it. So it's really hard to say that the right thing to do is to overturn a poorly reasoned decision, even if you think it's the right decision, and then get a decision based on good, strong foundation, good reasoning. Because in the interim, real people get hurt. So it's really difficult to say that Roe should have been overturned. It's pretty easy to say, well, it shouldn't have never been decided this way to begin with, but we can't really do that. This is what we're dealing with. And now you have to decide whether it's a good thing or a bad thing that it was actually overturned. And I think the only way we're going to know that is to see how everything ends up playing out. We will only be able to look back and decide whether this was a good decision or not. But I don't think that you can deny that there are going to be people harmed because of it.
Well, and the harm is going to be. I think people have misunderestimated. Jesus, wow. Okay. I think people have underestimated the harm as well. And the reason why I keep hearing this is going to knock us back to the 1970s. No, it's not. This is unprecedented. This is unprecedented in the history of the U.S., and here's why. At no time in U.S. history, to the best of my knowledge, were abortions routinely and actively prosecuted. At no time were they regularly considered in any state an act of murder that could either get you up on death row or have murder one charges brought against you. They are now. The states that are planning on repealing abortion as soon as Roe falls are planning laws on the books that have existed, to the best of my understanding, in the past, but weren't actually adhered to. A woman in 1975 who got an abortion did not face murder charges. Usually what they did was they got her to flip on whoever provided the abortion. Then she'd get a fine and that's it. We've already had in Texas a woman who was hit with murder. If I recall, it was murder one, premeditated murder charges of the fetus in Texas. Just because I think she'd gone like a day or two over the Texas limit. So Roe v. Wade was still intact, and she had murder charges brought up against her. It's impossible to know what's going to happen in the future, but I think the prediction that Texas is going to aggressively prosecute anybody who gets an abortion once Roe v. Wade is overturned, and in a way that is unprecedented in this nation's history, I think that's a pretty easy prediction to make. They've already been chomping at the bit to do it. That's why we're here. This isn't going back to the 1970s. This is going back to some time that hasn't even existed in the U.S. This is much closer to A Handmaid's Tale than, and I understand it. Even when I first heard this, that was my thought too. We're going back to the 1970s. And when somebody brought up A Handmaid's Tale, I was like, okay, that's a little hyperbole. And I'm sitting there going, that's not as much hyperbole as I thought. And the reason is because now you can be put to death for it. That was never the notion of putting a woman to death for getting an abortion. Just saying that would have been so slanderous and outrageous in the 1970s, in part also because just the notion of putting a woman to death in general, women weren't usually on death row or anything like that. That's what's going to happen, and I don't think that's slanderous or shocking to anybody. I don't think anybody listening to this is going to disagree with me on that. That's different, and I don't think it's the only difference by any stretch of the imagination, and I cannot even begin to express how serious it is that doctors would be expected to turn in any patient for anything, with the possible exception of the only exception that exists in the legal system, which is if your patient says they're going to commit a crime in the future. If your patient says, and if it's an ongoing crime like marijuana, drug dealing, whatever, no, that doesn't count. But if your patient says, I'm going to rob a bank in 3 days, yeah, maybe as a doctor, you should be obligated to tell people that. If your patient committed a crime, has nothing to do with the doctor. And that is a right to privacy you absolutely should have and should be non-negotiable. And the idea that doctors can turn in women for this, the idea that women can receive a life sentence for this, all of this is unprecedented and phenomenally dark. And the fact that it seems to have rolled so easily off the tongues of these justices is it's very hard. I haven't gotten my head around it, as I know most people haven't. I don't know. Is that now that I've said that, is there anything? What are your thoughts on that?
I keep trying to marshal everything around, and it's like there's definitely, there are certain states that have definitely telegraphed that they want to move aggressively on curtailing abortions. And I wonder how much, because I worry that might come true. I don't want to believe that we would go that far, but there is evidence to support what you're saying may come to pass.
But I think it will in Texas. I think that's I think that's been the promise of the governor of Texas, and I think he has every intent on keeping that promise. All right, again, just evidence from the last couple of weeks, not the least of which is the trigger bills that do make it either a felony or, I mean, and they've already tried to prosecute murder on it. Yeah, I think it's very dark. It's very troubling. I do actually agree in one sense, I think, with what Alito said about this not being a woman's issue. Because I think in the same way that people say trans rights are human rights, which they, of course, absolutely are, women's rights are human rights as well. It transcends being a woman's issue, where I think Alito was trying to disarm it and to say that you can't possibly, or that it's very difficult to suggest that somebody who is pro-life is being sexist, and that really the burden is on the person saying that. There's all sorts of issues with that. I agree that not everybody who's pro-life is sexist. I think especially a lot of religious people for any number of reasons. So, and some of them are wildly sexist, I think, as we all know. But I don't think being pro-life necessarily means that you're anti-women. But I don't think you can be nearly as dismissive as he was. But I do think that we're talking about universal human rights. And in that sense, it's not a woman's issue in any sense of the word. It's a human rights issue. And it's been enshrined by the UN as such, by the way. The UN has explicitly said it's a human right. And the notion well, we've been hit by the Human Rights Commission more than once for our stances on it, and this will no doubt get us whacked again, but I forget that I had reading. I'm not going to bother. I'm fading. But it's recognized by the UN as a human right, and I think this is I got to tell you, and I'm going to just I remember we had on Nate a while back talking about this, and we were talking about what we thought the court's decision was going to be. And of all the people who made predictions on what was going to happen with Roe v. Wade, and I made my predictions too, which was that they were going to take a serious whack at rolling it back, but they weren't going to overturn it. The only person who got it right was him. I really thought we were going to be laughing at his prediction. He called this one. He absolutely called this one. I'm not sure how to handle that. I'm just like, wow. Nate called it.
Yeah, I didn't believe it would be overturned either.
Were you there when he called it? Do you remember what I'm talking? Because he called.
Yeah.
This is what he said was going to happen. He made a number of other calls that have been really pretty close to.
I didn't believe that.
Yeah.
Yeah, I didn't believe that it would actually get overturned. I was actually kind of dismissive about it, going, it's been 50 years. No, I don't think this is going to get overturned.
Yeah, he did a video.
Obviously.
Yeah, please. Sorry.
Obviously, I was not quite right. And as to whether this is a woman's issue, because I've had people. I don't quite understand why they're doing this, because I'm actually on the side of the right to choice. But, I've been yelled at because I don't have a uterus. So therefore, I'm somehow not allowed to have an opinion on this. And I've always maintained through all of my views, even when I was, pro-life, that it's a human rights issue, not just a woman's issue. And that, society at large has a right to weigh in on whether, because there's a third innocent life being involved in this. So it's like, no, this is something that everybody has a right to decide, and that we need to come together and decide which rights we're going to uphold and which rights should take precedent. No matter what side of the aisle you're on, that would be true. It's either a right to life or it's a right to bodily autonomy, in my opinion. Those are the only two compelling arguments that I've come across. So in either case, that's a fundamental human right, So everybody absolutely has a right to weigh in on what fundamental rights human beings will have. Because as much as people are like, no, humans are endowed with rights by their creators, and governments just recognize that, and it's like, no, that's not really. I mean, it's great for a governing principle to have something like that. It's kind of like the governing principle that all people are created equal. In reality, that's not true. In reality, rights are granted by governments. And can take those rights away. We've seen this time and time again. There is no universal force out there that forces governments to recognize and understand, basic human rights. So we have to decide what rights are going to be honored and which ones take precedent, and that requires all of humanity because it's human rights.
I remember in high school, as a freshman, I think in high school, I got into my first serious debate that landed me in hot water, and I was in hot water most of high school ever since then with my positions. I was rabidly pro-choice, and I mean rabidly. I am not rabidly anymore. I'm absolutely, I'm still, I'm still on the left. I still hold those views, but I have to believe it was a sight to see. But I was also, I made another argument simultaneously, which is that men don't have a right to weigh in on this. They have an obligation, and unless you aren't sure. But the reason is one of two things ostensibly is true. And at the time, I was actually a theist. But I said, look, either you believe that in ensoulment, or that, this fetus is a person, and if you do, you're witnessing genocide. You think somebody is moral if they're witnessing what, in their honest opinion, is genocide, and they say, I'm not the one being killed, it doesn't affect me, and I'm not the one doing the killing, so I'm not going to wait. Give me a break. Give me a break. It's the exact same argument, and the South actually used that argument against the North. You guys don't have slaves, so it doesn't cost you anything to say slavery is immoral, that black men are really human beings. It costs you nothing to say that because you don't have to give them up, so you don't have a right to weigh in. That argument is ludicrous. So if you're pro-life, you have an obligation, at least if it's on those grounds. If it's on some other grounds, maybe not. But if you really think it's murder, I don't want to be friends with somebody who thinks that and is going to keep their mouth shut. I don't want to know you. And the reverse is true. If you think women have a right to their body in that way, if you're a guy, it's no different than if it was your body. It's no different. It's another human being. I would expect women to stand up for rights of men and not sit there and say, well, I don't have a penis, so it doesn't concern me. Fuck that. We're a species first, and our sex, gender, whatever, distant second, third, fourth, fifth, and sixth. So much more about us that keeps us together. I don't think that's one of the few arguments I've found silly and disingenuous too, because it's just a way to shut people down. Obviously, if you have a genuine belief in one of those positions, you are morally obligated to fight for it, because both of those are pretty strong positions. One way or another, somebody is having their rights taken away from them. And if you have a position and you decide to keep your mouth shut, what kind of human being is that? Give me a break. So, yeah. Nope. All right.
And the weird thing is, too, is in all of these arguments, I've been arguing for bodily autonomy because I found that argument to be compelling. I've said it I don't know how many times, and I actually changed my mind on this topic. And the thing that makes me sound like a really cruel, heartless bastard is that I found the bodily autonomy argument to be the compelling argument that that individuals have the right to control whether their body is used by another individual, even if that use sustains their life. And that's across the board. That's not just for pregnancy. That's period.
Yeah.
But I also point out that you're killing a human being. And you need to be cognizant of the fact that you're ending the life of a human being. And yeah, that may be uncomfortable, and it had better be uncomfortable because you are ending the life of a human being. I want you to go into that cancer hospital, sign up for all of your tests to see what kinds of donation, what kind of donor you are for all these different things: blood donor, bone marrow, liver, kidney, whatever. And then I want you to look at all those kids and tell you, I don't want to use my body to save you, because that's what you're doing when you get an abortion. I think that that there are tragic circumstances where it is the right decision to make, and only the person involved in that decision can make that decision. But to stop, it annoys me when people start using euphemisms. Oh, it's like a tumor. It's just a bundle of cells. That is a human being. It's what every human being looked like at that age. And you need to be cognizant of that fact when you're deciding, how your body will be used. So it makes me sound like a cold, heartless bastard, because I think that you should take into consideration that you're killing a human being when you decide to get an abortion, and that I will stand up and vehemently defend your right to it, because I believe in bodily autonomy. So that's gotten me into a lot of hot water before. Probably will again.
I'll bet. All right, Xander, thank you very much for that. Thank you for joining me tonight. Thank you, everyone here. And we are obviously going to be covering whatever happens on Monday. We're going to be covering whatever happens over the next couple of weeks. We're going to be getting back into the Ukraine. We appreciate your support. Join us on the Discord if you want to discuss this and any other topics. And we look forward to speaking with other people on other opinions and seeing you guys on our next show. Have a good night all.